Hi everyone, my name is Vlad Genshu. I am a personal injury jury trial lawyer here in Los Angeles, California. I have tried 15 civil jury trials to verdict. I have tried all of them either as a first chair with no second chair or with a second chair that basically has sat and assisted me with the paperwork. I want to talk to you today about a personal injury jury trial, what not to do in a PI jury trial. Basically, I want to teach you on what you need to do to make sure you don't fall into some very big potholes, which will probably sink your case. And I'm going to divide those into three aspects based upon my 15 civil jury trials. And on top of those, I have another three civil jury trials that settled before verdict. So I really have 18. So I'm going to divide these into three categories. The third one and the most obvious one is lack of proper preparation by the attorney and the attorney with the clients. That's something that you probably are most familiar with in terms of just the basic ethics that you need to come out of law school with, and that you'll figure that out even before you try a case, which is if you can't prepare your client, if you can't prepare yourself for the trial, if you're not going to get put in the, if you will, the sweat equity, then you're going to lose. That's something that you need to really think about. There's a great book out there by Johnny Cochran called A Lawyer's Life, and he says that the rules to winning a jury trial, the rules to winning, to getting a good result for your client, whether in front of a jury, in front of a judge, or in settlement, is preparation, preparation, preparation. You cannot forget that. Preparation, preparation, preparation. We'll talk about that a little bit later. The second thing is I would say you're not hiring the right experts. You're not really looking at the case from the defense standpoint. If you're on the plaintiff's side, you got to realize how they're going to try to disprove it. You're not looking at the proper medical experts, and that's going to cost you. And the first is the most obvious, which is you just have a bad fact pattern. And in a personal injury jury trial, a bad fact pattern is really going to cost you. And you got to be brutally honest with yourself. If you're an attorney taking cases from other attorneys because they're stuck, you got to be honest with yourself. You got to look at the case, look at the file, take the Dropbox file, and say, look, I'll get back to you in a week. I'll get back to you in a couple of days, unless, and if it's a take it or leave it, where there's says, look, you got to give me an answer in 20 minutes or so if you take this file or not. That's a horrible, proposition. You look at the file, be brutally honest with yourself and say, hey, does this thing actually make sense? Am I going to look at this case and do I actually think that I can deliver justice for this client, or is the fact pattern so bad? So I want to talk to you first about the first part, which is the fact pattern. When we talk about a personal injury jury trial, we're talking about either some kind of vehicle crash, car crash, motorcycle, truck, whether it's a pedestrian versus another truck or a car, whatever. You gotta look at all that kind of stuff, and you gotta look at the vehicle aspect of it. And that's gonna bleed into the second part, which is the experts. So let's talk about, first of all, your run-of-the-mill car accident case. If it's a disputed liability case, meaning it's not a rear ender, or it might be an offset rear ender. I tried one of those in Riverside County. You got to ask yourself, what kind of impact is this? Is it if it's a disputed liability, if it's a light dispute, if it's a dispute about who saw what, when, how did this thing happen? Do you got any witnesses to it? So if you have a light dispute, you got to ask yourself a couple questions. What is there a police report? If there's a police report, what does the police report say? Just because there's a police report doesn't mean you're going to be able to call the law enforcement officer and get much out of them on the stand. They usually cannot at all state on the stand who was at fault. So even if the police report puts the defendant at fault, the person you're suing, that doesn't mean you're going to be able to bring the law enforcement officer. Because think about it for a second. The law enforcement officer, whatever he says is hearsay. He wasn't there, or she wasn't there at the scene. So you got to look at it from, just because I have a police report, that might help you in settlement value, but that doesn't necessarily help you a lot in trial in terms of the actual conclusions. Now, can you bring the police report in and basically say, hey, defendant, you said this. Is it not true? You said that. Or you could bring the law enforcement officer. You could subpoena them to the stand, right? You bring them in and you say, well, what did you do? Whose statement did you take? And the law enforcement officer can say, the defendant told me this. That's a party admission. That's a hearsay exception. The plaintiff told me this. Did you come to any conclusions? Yes, I did. What are the conclusions? Objection, hearsay, evidence, and then you're going to get all those evidentiary objections that are probably going to get sustained. Lacks foundation, 352. So you're not going to probably be able to get the law enforcement officer's conclusion as to liability, even in a something like a light dispute, right? So you get that, but you can say, what did you do at the scene? I did X, Y, and Z. This is my regular training and protocol. Do you have a witness that happened? Well, if you have the witness, if you got the witness's contact information on the traffic collision report, the police report, you get the witness. You subpoena the witness either to the stand, or ideally you take their deposition, notice their deposition, let the defendant obviously know a deposition is happening and taking place, and then you see, what does the witness say. You can't call the witness before and say, hey, X, Y, and Z, because you remember, he's an independent witness. She's an independent witness, and there's no attorney-client privilege. I've seen cases where witnesses are represented by the attorney at a deposition, but most of the time you don't see that. So in any case, you do see that, and you want to get the witness's fact pattern. All what you're doing there is you're putting together the bricks towards your house of liability, towards your house of trying the case. So the fact pattern is really what happened at the scene, what happened at the location, who said what. You got to be brutally honest with yourself. You got to look at the property damage, okay? What's the property damage look like? Is it good? Is it bad? And that's extremely important, right? I mean, if your client's got a car that's a brand new car and it's got scratches on the bumper, you might want to question yourself if you're going to take that case, right? That's probably a substantial factor defense right there. That there was a rear ender, and they're going to stipulate the liability as in that they rear-ended your client. But I mean, is that really going to cause any injuries? That's what the defense is going to say, right? So you got to look at, even when you have what looks like a simple case, you got to really look at it from the defense's standpoint, which is, what's their move going to be? What's their move going to be? So if you have a liability dispute, or if you have a dispute on whether the impact could have caused any of the injuries, you're probably going to look at an accident reconstructionist and biomechanical expert. The defense is going to hire one to say what? To say that they're not at fault, and then to say that the impact, the loads and the forces on the car could not have caused anything. And then again, you got to look at the facts, right? Think about it. I had a case where I was representing the front car. There's 3 cars. We were suing the car in the middle. This case was a case that was given to me to try, and I had it for about 3 weeks before trial. And then the middle car was a lady who was in a very, very ill medical state. And then the front car was our 2 clients, plaintiffs. Every car was an SUV, minor property damage, right? There's no doubt that there was a rear impact from the third car, the defendant, who rear-ended the middle car, the second car, which then rear-ended our car. Very tough to see the property damage on it. They had Axe Recon Biomex on it, and a medical expert, a medical doctor. Why do we have that? Well, you have to ask yourself, does it make any sense that your client could sustain the injuries that they're, that a jury could say, yeah, we agree with that. And ultimately, we settled that case during jury selection, because I just thought it was a very tough case. That, the middle car basically said, well, I wasn't really banged up that much. How could they be? And that's a person who was going to be brought to the stand, right? And it was actually, she was going to be pretty convincing given her testimony, I thought. And it was actually kind of a slam dunk, her testimony, I think, to really cause us some issues at trial. So I said, you know what? I went to my clients and I said, here's what it is. And ultimately we settled for the policy limit, which was a minimum policy limit, but it would have saved the clients from getting hit with a massive cost bill, which probably would have been about $70,000, because the case was being litigated for 5 years. So you look at that, and you got to look at, there's like a smell test, right? If it reeks, then you got to be brutally honest with yourself. Usually the judge will try to help you out and they'll say, what are you guys doing here? They might try to set up a mandatory settlement conference and try to help you, figure out a settlement if it's possible. So you look at that, and that's what you call the smell test or the reek test. Whatever. If it reeks of problems, then it's going to be very tough to create, turn rancid lemons into lemonade, because society won't stand for that, nor should it. So you have to be brutally honest with yourself. Do you have a fact pattern that is frankly true, believable, and honest? And if you have, damages on the car that are massive, and then you have, even if it's a disputed liability case, if you don't believe what the other side is saying, what the defendant is saying, and you fundamentally believe, and the facts on liability, the testimony and the depositions and witness statements and the witness's deposition back your client, then yeah, try the case 100%. You got a good fact pattern. The defense is undervaluing the damages. They're undervaluing that. You should try the case. Now, the second part is what I would call just you're not properly investing the necessary amount of money, not the necessary amount of time. You already have a good factual pattern. So the question is, well, are you investing the necessary amount of money? And by that, I mean hiring the right experts. So presume that, the medical treatment makes sense. Presume that the fact pattern about the loss, about the impact, the injury makes sense. So now the next question is, do you have the right experts, whether they be medical experts, accident reconstructionists, biomechanical experts, human factors experts, economic experts about loss of income, earning capacity. The defense has this benefit, and it's a huge benefit, which is, when you're on the plaintiff side, you are coming out of pocket, and you're not really going to be able to put on a good case if you don't come out of pocket. So what you're really looking at is you're looking at a situation where you need to shell out tens of thousands of dollars on a legitimate case, possibly maybe even $100,000 on a big one, where you're basically saying to yourself, listen, maybe even more, I need to hire the following experts, and I can't prove anything if I don't spend money, right? That's a famous line in the movie A Civil Action when John Travolta says, I have to prove things and I can't spend money, and I can't prove things if I don't spend money, right? I got a lot of things to prove, and I can't prove them if I don't spend money, meaning if you don't hire the experts, you're not going to have to spend the money. You're not going to be able to prove them. And the defense doesn't really have to worry about that, because the defense, it doesn't really have the unlimited checkbook, but it has closer to it than most plaintiffs' firms do. Because think about it for a second. You're dealing with a plaintiff's attorney, right, who is working on a contingency fee. That's exactly what it sounds like. It is a contingent fee. It only happens when you only get your fee when the contingency happens. The defense, they call their adjuster, they call their corporate representative, whatever, and they say, listen, I think we need a biomech on it. So they got a list of 20 biomechs that they work with. We need a biomech / Axe Recon. We need a human factors expert. We need a medical doctor, an orthopedic surgeon. We need an economist or a billing expert. And you might not need to counter expert by expert by expert, but you need to look at it brutally and say, what do we really have? We have this situation here where we need to say to ourselves, listen, if they are going to bring these experts, are we going to bring these experts? Now, here's the brutal and honest truth about that. You don't need to match the other side dollar per dollar, right? Think about it this way. If they have experts ready at their call, if you will, on their beck and call, ready to call into court, but your case is worth $30,000 and you need to spend $40,000 to prove that $30,000, your client's going to lose. It's going to be the ultimate Pyrrhic victory, right? Maybe you only need a pain management doctor. A medical doctor is a pain management doctor. Maybe you only need a chiropractor. I've had a case where I hired a chiropractor. We hired him to testify, and we got a $66,000 verdict, and we only asked the jury for $15,000. Now, I think the defense, in all brutal honesty, they didn't really put up a great case. I mean, sometimes it's the other way around, right? But in that case, the defense didn't do much, and it was enough. We had a chiropractor. He was paid, I think, $1,500, maybe $2,000 for 1 hour testimony through video conference. It was enough. Right? But think about it the other way around. Imagine hiring $40,000 worth of experts for a case that ultimately gets you, if you're lucky, a $50,000 recovery, right? And how much is the client really going to net? $5,000, zero, right? You need to look at it, which goes back to the fact pattern, right? It's like you're building a pyramid. You're building a house or a pyramid or any kind of structure. The foundation has to make sense, right? Which is the foundation is the fact pattern of your case. If the facts are really bad and they've been developed in a way that's just the way they are, they're bad, and then that's going to be something that you need to, really question yourself and be honest with your client and say, look, I think we either need to cut it off here, we need to settle the case, we need to dismiss the case. If it's a really tough case, there's no liability, get a request for dismissal with a waiver of costs. You need to be brutally honest, because if you want to take out your credit card and start spending money on experts and jury fees and all that kind of stuff, and you end up getting not much for your client, are you really doing them a service, right? So ask yourself, does it make sense based upon the fact pattern, based upon the medical treatment? That's something that's also needs to be really discussed. You got to ask the client, if the client, if the medical treatment doesn't make much sense, or there's no medical treatment and there's actually no personal injury, or there's very minimal injury, or there's an injury where the client just, there's massive gaps in treatment or whatever. That's the fact pattern. Don't go investing. Don't go blowing your good money on a trial that your client's not going to recover anything, or you're just going to recover your costs, right? You don't want to do that. You're just going to get you're going to get experience. It's going to be on your dime and your time and your client's time and the jury's time and the judge's time. Don't do that. That's not right. So the other thing you need to ask yourself is, after you figure this out, you need to go to the third aspect, which is, okay, I put in the money, this is a good fact pattern. Then you look at the time you've invested. And the time, of course, begins with 1 and 2. So all these things really bleed in together. They come in together. The third is preparation. There are points where I would consider in a case that are credits and debits, meaning you're adding money, you're adding value and money to your client's case, and the debits, right, where you're subtracting it. I think that the most obvious debit is the deposition. Your client needs to be prepared for the deposition. He or she needs to understand some very, very important things about what a deposition is. Okay, first and foremost, a deposition is just as important as trial testimony. You usually have by the way, the other side does not have to give what are known as admonitions or ground rules, but they almost always do. You don't have to give them, almost everybody does. But I've been in one deposition, it was a business litigation deposition, it was almost 9 hours long. There was no admonitions. Now, that attorney had a relationship with my client in the sense that they'd been suing each other, and he said, why would I give him admonitions for when I already deposed him, or he's already been on all these depots anyway, so he knows what they are. Usually in a personal injury case, that's not going to be the case. There's going to be ground rules. But part of those ground rules, this is why the deposition is critical, is for your client to know, hey, guess what? This testimony, it's under oath, it's under penalty, it can be used at trial, in front of a jury trial. And it almost always is, and it's used for the purposes of impeachment, to destroy the credibility of your client, which is why spending, I would argue, 1 or 2 days with your client in preparation for that deposition is utterly, absolutely important. That's time. That's the preparation that Johnnie Cochran mentioned. You do that, you spend that time, you spend that effort, then you're going to be able to minimize the debit on that deposition. Remember, deposition is a debit, and it's taken for the benefit of the party that's noticing it, for the attorney that's asking the question. It is there to trick your client. It is there to cut money from your client's case, his or her case. Make sure, by all definitions of the word, that you prepare that client is ready for the deposition. Understand the difference between an estimate and a guess. Understand that your client has the right to take a break. Understand they have to answer the question before they take a break. Understand that while they can make changes at the deposition or later, that those changes can be commented on, and all their testimony can be commented on, and the credibility can be severely impacted. Understand what medical bills are, what a lien is, their treatment, all that kind of stuff. You cannot spend enough time getting your client ready. It's like preparing for a massive game. This is very, very important. It's the stuff before the game, the lights, camera, action. Okay. The other things in a debit, you got to make sure the client goes to the the defense medical exam. I would, if you got a big case, send a nurse there with you. Go there yourself, record it. You have the right to record it, not video record it, but record it. Okay, record it in through audio. Make sure you answer all the discovery responses well. Don't have there any useless motions to compel it to be put on calendar. And then after that, you got to prepare your client for the trial. What I would recommend is, if you're going in front of a jury trial in Southern California or anywhere in California, take your client to the courthouse. Take them to Orange County if they live wherever. Take them to the San Bernardino courthouse if they live in San Bernardino. Take them to the LA courthouse. Show them where they will sit so that they feel comfortable. For most people that are sued or suing, it is not a comfortable environment to be in court, right? For the litigants, for the people that are the people on the caption, the plaintiffs and the defendants, it is different than for an expert witness who is there every single day. If you see expert witnesses, whether they be medical doctors or whether they be accident reconstructionists, biomechs, they've done it, some of them hundreds of times. They will turn to the jury when they start answering questions. That's because they know how to do it, right? They're charging $5,000 to be there for the full day, or $12,000. Of course they know how to do it. And while it is the case that they're working on, it is not their case. Okay, I assure you that medical doctor, if he was being sued in a malpractice case, it would be a totally different, feel for them, being an expert witness in somebody else's case, right? Or if some accident or reconstructionist is being sued by their ex-spouse or spouse in a divorce proceeding or child support, being on the stand in that case will be very difficult, will be very different and difficult. So my suggestion to you, when you have your client there, plaintiffs are almost always one shot plaintiffs, meaning they've taken the stand only once, and that's their first time, that first once and only. Take them to court before, take them the day before, take them the week before, show them where they sit, right? It is not something, as attorneys, especially those of us who have tried a lot of cases, right? I'm going to come up on 20 trials pretty soon. It's very simple to walk in there and it feels like it's home to you, right? It's like, hey, it's another day at the office. That's not the way your client feels. That's not the way he or she feels. Take them there, sit them there, have you explain to them how it happens. That's part of the preparation. You cannot prepare enough on a case. Jerry Spence, a lawyer that I'll be lucky to be 1% of or 2% of, he said every civil case can be won. That does not mean that every civil case is worth $1 million, $1 billion, or even $100,000. But what it does mean is that every civil case you can beat the last offer made by the last side, and that works on both sides, the plaintiff or the defense. I'll tell you this: my best case was a case I did pro bono. It was for a friend of mine that we're coming up on 20 years of friendship. It was I was representing him. He was the cross defendant, the original plaintiff in a huge business litigation case. He was being sued back for about $2 or $3 million. And the reason why it was so easy to prepare him is I've known him for 20 years, right? We're very close friends. I did it pro bono. I took 7 depositions pro bono, and I tried the case with him for 3 days. We went to the Moss Courthouse, downtown LA. And we ultimately settled it during the jury trial for a fraction of what they were suing him. Why was that case so successful? Is it because I understand business litigation? Not that much. I understand enough to be able to pull it off. I understand jury selection and the general themes, doing personal injury. But I understood my client, and I understood his case, and I understood who he was and who he is. And as a result, we were able to pull it off, right? The other side probably spent millions of dollars in attorney's fees. We were able to pull it off because we had that client-attorney chemistry, that professional chemistry, which will get you a lot, even when you don't understand the law on that specific topic. I'm not saying don't understand the law. I'm saying understand the client, understand the human being first. That's what Trial by Human is all about. I wish you the best in the next case. I know you'll do great. Remember, you cannot prepare enough. All my best.